how to structure the legal ownership of an RIA. That is today's question on the Transition to RIA question and answer series. It is episode number 52. Hi, I'm Brad Wales with Transition to RIA, where I help you understand everything there is to know about why and how to transition to the RIA model. So on today's episode, we're going to talk about, how to set up the legal structure of the RIA from an ownership perspective. So I've done a number of episodes. You can go back and find those. I'll link to some of them in the show notes. But I've done a number of episodes on how to set up the RIA itself from a logistical standpoint. And typically you work with compliance consulting firms or specialized attorneys that can help you with that. And so there is a whole process, a whole timeline, steps involved of how you set up the RIA itself. Like I said, lots of episodes I've done. You can learn more about that. But what we're going to talk about today is, and this is a question I get often, is, okay, but who can technically own the RIA? Can I own it in my individual name? Is that an option? Well, what happens if there's me and other partners? And then it's also, hey, can we set it up maybe in the name of an entity, an LLC or something like that? And why might we want to consider doing that? And so that's what we're going to be talking about today, because it is something that comes up quite often and is a quite important part of starting up your own RIA firm and checking those boxes. So with that, I have a wonderful guest on today. As you can, any of those watching on screen can see, good friend Rich Chen with the Richard Chen law firm. Rich, thank you for joining us.
Hey, thanks, Brad. It's great to be here.
Yeah, I think we're going to have a great conversation. I'll ask Rich to give a little background on himself and his firm here in just a second. But like I said, this is something that is important to think through. And this is the classic case of the blocking and tackling of starting up your own firm. There's certainly things that are more exciting about starting up your own firm. Maybe the marketing. I got to do a brand and how I'm going to position in the marketplace. But there's also a lot of the check the boxes things that are very important to get right on the front end, not only because what might be required today, but also forward looking of, hey, I want to position myself well, because as things change over time, I don't want to, put up any hurdles now that could come back to bite me. And so part of that is, hey, how do I set this up from an ownership structure? So that's what we're going to be diving into here. So Rich, if you could give us a brief background on yourself and your firm, I think that'd be quite helpful.
Absolutely, Brad. So I've been a practicing attorney since 1998. I've been working in investment management for more than 2 decades. I founded Richard Chen PLC about 2.5 years ago. We serve predominantly SEC-registered investment advisory firms with all kinds of strategies, and we provide a broad scope of compliance, program development and management services, SEC mock audits, SEC registrations, and representation in SEC exams. But on the legal side, we help firms to structure their ownership and compensation structures. We help them to review and negotiate commercial contracts with service providers, develop their own client agreements, employment agreements, and manuals. We also do M&A and joint venture and succession planning work for advisors, and then private fund formation and operational due diligence on funds.
Fantastic. That's a lot of topics. I can tell you, well, 2 things I'd point out. One that Rich omitted, but I think it's quite fair to point out, he is a Harvard undergrad and a Harvard law school. So quite humble that you didn't even mention that, but quite the credentials there from your background. And then if you think, oh, wow, he just named off a bunch of topics, could he really be a subject on all those? I'd encourage you, if you're not already connected with him on LinkedIn, and today was no exception. I saw one of your posts from today. His knowledge runs wide and deep of the different topics he posts about and provides information on. So certainly as part of this, find him on LinkedIn, and lots you can learn from all of the content, Rich, you're putting out there. So thanks for it's quite a lot, and like I said, wide and deep. So good job on all that.
Oh, thank you so much, Brad. It's a joy to be able to be a resource and to be helpful to RIAs, whether they're starting out or well established.
Terrific. Well, let's dive in. So the first kind of initial capstone part of this question is, and maybe I'll just keep referring to me as if I'm an advisor, I'm starting an RIA, is can I have the ownership, the formal ownership of it? Can it be an individual? Does it need to be, Brad Wales? Or if there's particular reasons, and by the way, a disclaimer, we'll get the disclaimer out of the way at the top end. Some of these aspects you would want to bring in your CPA, your accountant as well to talk through what your personal tax situation is. So this will be at a macro level, what we're going to talk about here. But at that macro level, is there options to set it up as in the name of the individual? Brad Wales owns this RIA, or do I have the option to have, maybe an LLC own it and I technically own the LLC? So what are our options and why might someone do one versus the other?
Great question, Brad. You can technically set up as an individual, although extremely few RIAs actually do that. And there are a variety of reasons for that. The most important is that entities like LLCs and corporations allow you to have what's called asset protection. And basically, when you look at an entity and sort of the business that you conduct through it, when it's the formalities are honored, it protects your personal assets. So your house and your retirement account and all sorts of things from the potential reach of those that might be dissatisfied, over time with the services that you provide. Basically, the only thing that they can really go after are the assets in the entity. And so it is a huge benefit. Obviously, E&O insurance is helpful, but the structuring through an entity is helpful. Another reason people do it is because they want to build an enterprise, build brand equity. For instance, if you have a name that you brand under, or you're building an enterprise that you can, if you so desire down the road, sell it. That allows you, if you do it through an entity, to facilitate that process.
Yeah, I think it's interesting that almost any industry out there, small business startup, you always think it's in an entity, and it might be the majority of folks now that do it. But I definitely see folks that have it still as an individual. And I think these topics here are something that should be kind of, taken to heart on that front. So with respect to the entity, and again, there's disclaimer, there's, tax considerations that you'd want to, go through as well. But is there any limitation to what kind of entity? I mean, is it only an LLC is allowed? Is it only an S Corp? Is it only a partnership, or is there any kind of regulatory limitations there?
No, there aren't any regulatory limitations. I mean, the certain entities like LLCs and corporations are the entities that provide you with the asset protection, and so that is important. By and large, most RIAs set up as LLCs, limited liability companies, and the reason for that is because the LLC gives you a tremendous amount of flexibility in terms of how you structure your ownership, your rights, and there are some basic buckets of rights that we'll go over later on. But partners can contribute different amounts, receive different amounts in terms of profits or equity in the business. You have pretty broad flexibility in an LLC, but you have less flexibility in an S Corp or a C Corp, where there are sort of disadvantageous sort of tax consequences. So by and large, people set up as an LLC.
Okay. And I assume with the LLC itself, there's no limitations over. There might be limitations on the number of owners you can have, but what that ownership split is. But even back to that, at that RIA level, if someone was, for whatever reason, wanted to have an individual or individuals as the owners versus an entity, or maybe a combination of the two, is there any minimum from a regulatory perspective? Like, Rich, you and I, if we're advisors, we start an RIA. Is there anything that says you can't, you own 99% and I only own 1%? I mean, is there any minimum amount of ownership interests that the regulators require for someone to be called quote unquote an owner, or does it, whatever works for the individual advisors?
Yeah, good question. No, there's no limit. And that's part of the beauty of the LLC, is that flexibility. You can contribute as much, you can own as much as you want to. it's total flexibility in terms of the owners. A lot of people own it through individual ownership, but some folks will do it through entities like trusts. You can do your estate planning through your LLC. And if you worked with an estate planning attorney, it can potentially be advantageous from a tax planning, estate planning perspective for folks, and so it's definitely something to look at and to think about for how that can be beneficial for an owner's tax circumstances. Another thing that can be beneficial is that you want to think about the fact that LLCs actually can be taxed as either a partnership or an S corp, and this is where it is important to talk to an accountant to figure out which election makes sense for the individual owner. So even if it's structured as an LLC, there's a lot of flexibility on ownership and what tax elections that you take.
So for the people that are currently, and I've seen it, we're going to get into kind of where all this information is publicly or privately published, but a little spoiler, it is in the ADV, and so I have seen plenty, it might not be the majority, but plenty of ADVs when you go down that ownership part, and it is, Brad Wales 100%, and it is in that person's individual name. Do you know, do you think that the question is, okay, well, why would anyone do that? For all the reasons you said, it makes sense as an entity. Any guesses why? Is it maybe just not aware of the options that they could do it in an entity? And then to the degree someone's maybe watching this that already has an RIA that does have it under an individual name and now has realized they have some options, can it be changed after the fact, or is it decided only at the time the RIA is set up?
Yeah, it's a good question. I really don't know what the benefit of setting up as an individual to own an RIA really would be. But the good news is that, with some maneuvering, if you own an RIA individually, you can you can transfer the ownership to an LLC. There are definitely certain things that you will have to do and to consider, including potential assignment of client contracts, revision of the Form ADV, and things like that. But it's doable. So it's not like you're stuck if you're owning in an individual as a firm as an individual and you want to switch to ownership in an LLC. It's doable. You just have to jump through some hoops.
So ideally easier, doable, but easier to just, I don't want to say do it right, but it's do it maybe most effectively or efficiently on the front end. Obviously save on some cost and headaches to not have to change it down the road.
Absolutely right.
So what is on those episodes I've referenced talking about setting up the RA, and I just talk about how long that takes. So let's say again, Rich, you and I are advisors. We're starting up an RA. We've watched this wonderful video of that we've episode here that we've made, and we say, you know what, we should do this as an LLC. What is the process for setting up, for anyone that's never done it, an LLC, and maybe how long does that take? Is that a couple days, a month, or what's that look like to actually set up the entity?
Yeah. And so the good news is that process can be relatively quick. It's basically you file what's called the Certificate of Formation or Articles of Organization, depending on the state in which you organize. And you can, get the next day turnaround if you want to, or even same day turnaround. Basically, once you file that and you get a return evidence back from the state, then you are organized officially. But there's some other steps you need to do. Typically, you want to get an employer identification number, for a variety of reasons, and you can apply for that online. But the biggest step is that you will need to put together an operating agreement. And particularly if you have two or more owners, that lay out the rights of the parties. And there's two buckets of rights, which we can talk about. Basically, rights with respect to the management and decision-making, whether it's on a day-to-day basis or just with respect to extraordinary decisions. And then you have to allocate economic rights, right, with respect to the ownership of the entity, the equity in the business, as well as how you decide to divide up the profits, right, of the company through distributions. So, that's why the operating agreement is the biggest step, because it requires making decisions in terms of how the LLC will be governed, and the decision making will take place.
Yeah, and I thank you for bringing up the operating agreement. I was going to bring that up, not because I'm smart enough to know about them, but I've heard you talk about them before. And so, to be clear, that's kind of a separate. That doesn't go to the state, or that's not part of the filing entity. That's just almost a private. And you of course would know the legal term better than I do. That's just kind of a private agreement between whoever the individual owners are. Of, hey, let's memorialize what we've kind of verbally sat down and agreed to of how we're going to run this thing and how the economics are going to work. But that's only between those two parties, right? That doesn't really get shared with anyone else, unless there's ever an issue.
It doesn't get shared with regulators. Your bank may want to see it when you're setting up the bank accounts, but by and large, there's no regulatory review or approval of your operating agreement. That's purely between the owners.
Okay. So I mean, it sounds like the actual filing, again, we keep saying LLC, but it in theory could be a different entity. Yeah. The filing itself sounds pretty simple for someone that knows what they're doing, pretty quick, but it's that operating agreement that sounds like takes a lot more consideration of thinking through all the variables.
There may be a couple other things to think about. If you organize in a state different from where you practice, you may actually have to also file an application for authority in the state where you're actually doing business. And the other thing you may do, if you want to set up your RIA in doing business under another name, you may need to file certain filings with fictitious name filings with this, the jurisdiction, to make sure that you can use the DBA instead of your legal name of the entity itself.
Okay. Yeah. And a thing I would, as you were describing all of those nuances, that a reminder I've pointed out a lot of episodes, I'll point it out again here because it's important to, is to, no one should be intimidated by any of this. When you start your RIA, or you move into the RIA in some other model, maybe you join an RIA firm, there's a lot of steps involved in that process. And that's a thing I routinely help advisors with and understand. And in each one of those steps, there's a defined process for how to manage it. And you need to know what the process is and know the people to lean on to help you with that. And so you might be taking notes on some of this stuff, but the idea, and of course, Rich is obviously an expert on this, is don't be intimidated by this. What you do need to know is that, okay, there are variables here that need to be considered. Who do I lean on to help me understand all of that? And there are folks, again, Rich being one of them, that will walk you through all this. And it's nothing that you need to feel you're not going to be able to accomplish as long as you have that proper guidance. So, I think important to keep in mind. So next question, the example I would give, and then you'll see how this relates to this topic. So as I'm talking to advisors, again, they're thinking about starting up their own RIA. And so part of that conversation comes into like, what's the interaction between the RIA and a custodian? And we talk about all that. And oftentimes I'll point out, why someone might be, as they say, single custodian and multi-custodian. And I saw a stat the other day. I think it's like 2/3 of RIAs are multi-custodian nowadays. And what I always point out to advisors with respect to that conversation is, hey, usually you might start single custodian because there's some simplicity when you're first starting up to do that. But plan for the long term. So plan for circumstances that might arrive at some point. That won't go into in this episode, but there's reasons it might make sense for you to be eventually multi-custodial. So don't do anything on the front end that's going to make it difficult for you on the back end to possibly take that, perhaps almost inevitable step. So circling back to this topic, how would that apply, or what should advisors make sure they're not boxing themselves in? So I'll give an example. If I'm an advisor and right now it's just me, and maybe I have a team of people, but at least I'm the only ownership or the only owner of the practice. And I set it up now, but who's to say in 5 years, 10 years, 20 years, whatever the case is, there might be need for additional owners or additional partners, whatever the case may be. So any thoughts on things you should do on the front end to make sure you don't make things more difficult on the back end with the expectation that your circumstances could change over time?
That's a great question. So I think the important things to think about are the fact that, these documents can and should evolve over time as the business does. So you have to make sure that the provisions that allow for amendment of the operating agreement are sufficiently flexible and agreed upon by the members of the LLC so that you can make those changes down the road, because invariably that will happen, right? So it's important to have that flexibility and also important to have good dispute resolution mechanics, right? Because if the parties, especially if there's let's say two owners with equal ownership, right, you need to have ways of managing disputes that are spelled out, and so that the parties can be happy that, if we come into an issue that we have a problem with, that we can resolve it. But it is important to realize that these documents are living and breathing documents that will change over time.
Yeah, and I think that just reinforces again the importance, certainly, of not taking the cookie cutter operating agreement template, off the proverbial shelf, filling in a couple names and then thinking you're all set. It's worth the time and resources on the front end, one, to do it right, and then per what you just said, so long term you have the needed flexibility for change in circumstances. So we talked about that operating agreement is a private document, for lack of a better term. That's my layman's term. So it's not necessarily shared, except for maybe beyond a bank or whatnot. But the actual ownership of the firm, who all and where all is that disclosed, whether privately, maybe directly to the regulators, or publicly, the ADV? And maybe I just answered the question, but because some of it is public knowledge, where is that ownership disclosed, or who is it disclosed to?
Yeah, so it's actually disclosed in Form ADV in Schedules A and B and potentially C if there are amendments. So basically, anyone who owns more than 5% of an LLC or an RIA entity will be disclosed on the Form ADV. And if there's an indirect ownership, let's say an entity owns an interest in the LLC, the indirect owners would also be disclosed if they own more than 25% of the entity that holds the LLC interest.
And that could be a silent partner kind of thing, but still, because they own enough, it would need to be listed.
Yeah, basically, they want to go up the chain. If there's sufficient ownership of an entity, they want to understand who owns that. That's right.
Okay. So related to that, and I'm a big proponent, anyone that tunes into my episodes, I'd always try to be a straight shooter, give pros and cons. Everything in the world, there's pros and cons to. So clearly setting up under an entity structure seems to be the better way to do it for a lot of the reasons we just stated. But it can perhaps add some complications as well. I'll give an example, and then Rich, if you have any you want to add. When I worked at a custodian during part of my career, I was on the committee that approved or reviewed and approved any new agreements with RAs that wanted to use that custodian for clearance services. That's a pretty typical thing custodians do. Obviously, you want to get comfortable with them; they need to be comfortable with you. And so part of that is looking at, hey, who are the owners here involved, and maybe reviewing a CRD and things like that. And if it was an entity that owned it, and maybe more than one entity, we generally had to peel the onion back and start saying, okay, well, who owns the entity? And then it comes into, well, what percent do we care about the person that owns 5% of the LLC or just above that? It's all doable. It does slow that process down, and most custodians will want to break that wall down and say, okay, great, it's an LLC, but now we want to know who owns the LLC. Any thoughts on that, or any other circumstances you come across where an entity maybe makes it actually more challenging that just would be worth being aware of?
Well, I think that's right. And I think custodians, and I would add banks as well, would probably want to know about the indirect owners, because they want to know who they're dealing with, whether it's for anti-money laundering or other purposes. They'll want to peel the onion back to understand who the ultimate people who are owning the entity and responsible for how it is being governed. That being said, I think if you find that there are benefits, for instance, through through estate planning, to have an entity, I think that those benefits, in my opinion, can far outweigh the hassle of having to explain, who owns my entities that own my LLC. But it really depends on the circumstances.
And so when you mentioned estate planning, as you help folks with this, I mean, are you sometimes kind of being the quarterback and realizing there's a couple parties involved in this, whether it's estate experts or accountants? I mean, is that something you typically see as you're helping advisors get all this set up?
Absolutely. I strongly encourage folks to work at the very least with an accountant, because it's critical to understand the tax circumstances of the owners of the entity, because there are important decisions to make. It's definitely not a cookie cutter exercise to structure an LLC, and to the extent that estate planning makes sense, to bring those folks in. And so, we help to quarterback that process to make sure that all of these considerations give a full picture of what is best for the owners of the RIA.
Yeah, I think it's just a lot of moving parts, and again, nothing to be intimidated by. It's just working through a defined process of how to manage this part of the whole, setup of your own firm. So that's certainly helpful. Any other takeaways? I probably haven't asked every question that could be asked. You help folks with this, so you probably get asked questions. Anything you think I haven't asked that would be helpful for advisors to at least be thinking of initially as they kind of consider all of this?
Yeah. So, I mean, I think there are a lot of decisions that are made, especially when you're putting together the operating agreement. Oftentimes people want to address what happens if, one of the members wants to leave or has to leave, right? Death or disability, bankruptcy, divorce, retirement of a partner. What happens in those circumstances? The operating agreement helps set some parameters for how those things will be handled in the event that those things take place. But even from a day-to-day standpoint, looking at, as we were talking about, the management of the RIA, right? Who makes day-to-day decisions? Who's going to be responsible for what? Who can sign on behalf of the RIA, right? On the management side, and are there things where, people will have rights to consent or veto, right? With respect to big decisions. On the economic side, there's decisions to be made with respect to profits, distributions, and potentially you can have people who have a profit interest who don't technically own the RIA. For instance, potentially employees down the road that you want to incentivize to stay with the firm, you can give them a profit interest without having an equity interest. The other thing to think about is the equity and how you will divide that up between the partners based on what they contribute. So lots and lots of decisions that help day-to-day governance, but also think about the worst case scenarios. What happens if we don't all get along? How are we going to handle things at that point?
Yeah, and that always comes back to it's much less expensive to try to tackle those things on the front end correctly than trying to potentially have to unwind something that gets messy on the back end because it maybe wasn't fully thought through on the front end. My guess is that can be exponentially more expensive on the back end if it's not done right.
Yes.
And by the way, one last question. I think we started talking about it and then got sidetracked. How long, if an advisor were to call you up today and they want your help with this, and so some of that's in your control, Rich, some of that's in the advisor's control, but I mean, start to finish, what's your ideal timeline you would like if you were helping someone with this ownership process and then the filings and all that stuff? What kind of window of time is ideal for this process to play out?
We can do the process as little as, a week or two, potentially, if we get all the information we need. But generally, I think it's worth it to bank at least a month in order to think through decisions, particularly if you have multiple owners and you have to have discussions about how you want to handle things. Because the way we do it is we provide an initial questionnaire to folks to help them think through a lot of the key decisions. And then they go back and have that discussion and come back to us. And then between that and also coordinating with accountants and if necessary, estate planning attorneys, it takes some time to make sure that everything's thought through properly. So a month is a good amount of time.
Okay.
Yeah.
And then what is, as we wrap up, and I'm actually been bad about not pointing this out on all my prior episodes, so I got to get in the habit of pointing it out. I have Rich on the show. He's not paying to be on the show. I'm not paying him to be on the show. I just think he's a wonderful resource. I think this episode has proven that. So there's no financial interest either way, or if I refer people to him. So just to be clear on that front. But for people that are interested in this topic, that do like what you've said and do want to explore these topics further, what is the best way to get a hold of you?
Yeah, so I always welcome the opportunity to connect with people and just to be a resource. You can email me at rich@richardlchen, RICHARDLCHEN.com. You can connect with me on LinkedIn, and our website is www.richardlchen.com.
Perfect. And I will make sure each of those 3 items are in the show notes for folks that want to circle back. And again, certainly the website's great, email's great, but I've learned a lot myself following Rich on LinkedIn. So at a minimum, I encourage people to reach out and connect with them that way. Great resource there. So to wrap up, like I said, my name is Brad Wales with Transition to RIA. And if you're not already there, if you head on over to transitiontoria.com, that's where we'll have the show notes, all kinds of episodes, both in video format, podcast format. I have white papers. You can certainly reach out to me. That's my contact information right there on every page of the website to reach out. And again, we'll have Rich's contact information there as well. So with that, we'll wrap up. Rich, thank you very much for coming on. It's I always say these sorts of things aren't necessarily the sexiest of components to launch in a firm, but they're often some of the most important. So thank you for sharing all your knowledge with us.
Brad, it's been a pleasure. Thanks so much for having me.
All right. Thanks all.